So this video I'm going to talk about Michael Caperton versus Jacqueline Caldwell for the Kentucky Court of Appeals for the 3rd Appellate District Division 1. And that includes the counties Adair, Bell, Casey, Clinton, Clay. Now pay attention, because if your county is not mentioned, then you don't need to worry about this race at all. If it is mentioned, then this is totally all about you. Okay, so Adair, Bell, Casey, Clinton, Clay, Cumberland, Estill, Girard, Green, Jackson, Knox, Laurel, Lee, Leslie, Lincoln, Marion, McCreary, Metcalf, Monroe, Nelson, Pulaski, Rockcastle, Russell, Taylor, Washington, Wayne, and Whitley. So if you're part of those 27 counties, so there's 27 counties in Kentucky. You have the governor's race and auditor and the agricultural commissioner and all the rest of the executive positions. But for those 27 counties, they have a judge's race. And the judge's race is between two people, one who's a current judge, Caperton, and one who's a lawyer, Jacqueline Caldwell. And I want to talk about Michael Caperton, okay? So I'll start with policy. These are the 10 reversible errors of Michael O. Caperton. So if you go to trial court, that's the first court, and then if you appeal it, that goes to the appeals court, and then you could appeal that, and that goes to the Supreme Court. So there's 3 levels of courts. They're running for the appeals court. So the appeals court, they do not retry the case from the trial court, which would be your district judge, your circuit court judge, would be your, the first court that you go to. And it's what they do, they don't retry the case, but they find errors. They find errors in the process. If it wasn't a fair and impartial trial, then they'll find these errors, and then these errors will overturn the case, and they'll have to redo it or do something else differently. So the reversible error, that's the term you should remember when you're asking these appeals judge candidates, what are the reversible errors? What do you believe to be a reversible error? When does the trial court mess up so bad that you're going to overturn their decision and then say they need to do a different one? So the very first thing that Michael Caperton mentioned was that the accused cannot have their previous record admitted into court. They can't have why they can't have their previous record admitted into court, because that would prejudice the jury. So Caperton, he mentioned criminal rule 44B, and he says it's so rock solid, it's so strict that even an accused murderer, if he had murdered before and it was in a similar style, so the mode of operation, the signature to the murder, even if they had done, a previous murder and it had done, was done the exact same way, that wouldn't be allowed into the court because of criminal rule 44B. And he says by having the previous record admitted in the court, that prejudices the jury, and therefore it's not a fair trial. So he also mentions that the judge must grant the accused a public lawyer if they can't afford one. So he actually didn't think that a judge would do something like this, but if a judge denies a person of a lawyer, that's a reversible error that can overturn the case. The judge must grant a jury trial to any person who demands one. If not, reversible error. A client's own attorney cannot testify against their client. Now, some weird shenanigans went down with this case, Jose Gonzalez versus the Commonwealth of Kentucky. So Gonzalez v. Kentucky, and that's 2010 CA 0000295MR. And what had happened was that Jose Gonzalez had filed for a motion to undo his verdict. And the attorney had said that they explained it, but he said he didn't understand the attorney. He understood the judge, but not the attorney. And so the judge went ahead and called the attorney to the stand and said, well, what did you say? And the attorney for Jose Gonzalez is testifying against Jose Gonzalez in court. So Caperton reversed that trial judge's decision. The judge must always give an atmosphere of impartiality. This comes from the 2015 Marion decision. Michael Caperton is going to reverse and remand the trial court for 2 reasons, and one of those reasons was that the judge had told an emotional witness who kept on leaving the stand, storming out into the hall, coming back, but that was their star witness, the prosecution's star witness. They just finished the testimony, and the judge said that. So the judge just said, hey, you did a good job. He said exactly or she, whoever the judge was, said to Norris, who was the main victim, he said that Norris did a fine job and you answered the questions truthfully, I'm sure. And that was it. And so while that is not clear, right, you answer the questions truthfully, I'm sure. Like how? Like, oh, I'm sure, or I'm sure you did. So the judge in that outfit said that they were consoling the person, but because they had actually took a stand in the case, it has to have an atmosphere of impartiality, meaning it has to be a fair trial. So the judge, since the jurors look up to the judge so much, if the jurors look up to the judge and they think that the judge wants, the defense or the prosecution to win, then they will go along with that judge if it is not impartial. So because the judge said to the witness, you did a fine job and you answered the questions truthfully, I'm sure, it seemed that they were, essentially picking the side of, Norris, who was the victim, but it doesn't seem, it seems like you had a judge in the outfit that, that was sitting there saying, well, this, all right, this criminal here, I've heard some judges say some pretty, so anyways, the atmosphere. There has to be an atmosphere of impartiality. So just that little sentence, you did a fine job and you answered the questions truthfully, I'm sure. And then later on they try to admonish it, which they say the jury will disregard that last remark. I wasn't saying that they, were the correct people. What I was saying was, he was emotionally distraught, and I was trying to comfort him. But Caperton overturned that case because of that sentence, that one little tiny sentence, threw the whole case out. Courts must abide by due process, by a fair due process. This is number 6. This was in the Norton v. Perry case. Caperton wrote the opinion on it. Local planning and zoning laws cannot undo current buildings constructed prior to the law. So you pass a planning and zoning law, you can't undo the construction. There's these people that had a carport, the Felties, and the Felties got to keep their carport. The trial court cannot force a person to pay child support for a child that is not theirs. So a 2013 joint custody case of Jim versus Skiff. Jim paid 4 years of over $1,000 per month to Skiff for their 2 apparent kids, but later on found out that one of the kids was not his, and the trial court was going to still make Jim pay the child support for the child that wasn't his. Well, you've been doing it, so why don't you just keep on doing it? And the wife had said that it wasn't possible that one of the kids wasn't his. And then later on, a DNA test said that it was, not his, so she lied. And then she had also said, well, I got raped. So she just kept lying in that case. So anyways, if you have a kid, you don't have to pay child support for that, kid that you don't have. A trial court also cannot force a person to pay child support for an adult. So once the child becomes 18, is graduated, by the time that they become an adult, so I guess by the time they turn 18, then the child support is cut off. And there's no mechanism actually to get the, you have an adjustment in child support. The only way you can have an adjustment in the child support with the statutory cases is when there's a 15% change in income. So if the, ex-wife, ex-husband, if they're making more, making less, if it goes up or down, then you can have a motion to change the child support for an adjustment of child support. And that's the only thing by statute that is allowed for you to apply for it. But, it seems to me if you have a kid that's not yours, you can adjust the child support also if the kid turns into an adult. Well, they're no longer a kid. You can't, you're paying child support to someone who's not a child, and it's to, the other parent, so it's not to the actual child. So anyways, when they become an adult, you don't have to pay child support anymore, and you can apply for an adjustment of child support. And number 10, courts must allow an attorney to attempt to impeach a bad witness. Now this one confuses me because it completely contradicts Criminal Rule 44B, which is where he said you can't introduce previous rulings. Now maybe there's some middle ground here that I'm not In Caperton's 2015 Marion decision, he writes the opinion, and Caperton reverses the trial court's decision for two reasons, and one of them was because the defense counsel wasn't allowed to impeach an opposing witness with an obvious bad character. And so what was mentioned in the appeals was that she had a theft charge, and they wasn't going to mention that the Barbara Parrish had a theft charge. Now, this goes against the first thing you said, where you can't mention any previous convictions because that influences. But I guess she wasn't on trial. It was the other person that was on trial. So there seems to be some contradiction there. I mean, maybe he could work it out more specifically, but it just seemed to me that you can impeach a witness with an obvious bad character, impeach them by, cross-examining and say, hey, well, you're not even a good, witness. You're a bad witness, so why should anybody trust you? And so I guess that's okay to introduce other witnesses, their previous. That would influence the jury too, so I feel like you can't mention anybody's previous convictions, right? So I want to know what Caperton's thinking is on that, because he also mentioned two issues were appealable but not necessarily reversible. He said that a trial court must allow a victim to speak about their hospital bills. You don't have to pay $10,000 to get the doctor in there to testify on it. So he did mention on the backside an issue that could be brought up is to determine what is precisely reasonable and necessary medical operations. So you can't get any more medical operations than what what is absolutely reasonable and necessary. But a trial court must allow a victim to speak about their hospital bills. If not, that's appealable. Jacqueline Caldwell believed that if hearsay is introduced into the trial court and it has substantial impact on the trial court's decision, that's a reversible error. Caperton agrees with that basic principle, but he also mentions that everything that's said and written outside a trial court is technically hearsay. So those are the 10 reversible errors. That's the policy of Michael O. Caperton as the appeals court judge. The accused can't have their previous record admitted in the court. The judge must grant the accused a public lawyer. If they can't afford one, the judge must grant a jury trial to any person who demands. Its own attorney can't testify against their own client, so your lawyer cannot testify against you. The judge must give an atmosphere of impartiality. Courts must abide by a fair due process. Local planning and zoning laws can't undo current buildings constructed prior to the law. A trial court cannot force a person to pay child support for a child that isn't theirs. A trial court cannot force a person to pay child support for an adult. And courts must allow an attorney to attempt to impeach a bad witness. So maybe that's the defense attorney. So that there is a difference, I guess. Barbara Parrish was the witness against the accused. So the accused, but, if you can't, what's good for the goose is good for the gander. If you can't mention that the accused had a prior murder charge, how can you mention that they had a prior theft charge? So anyways, those are the 10 impeachable reversible errors of Michael Caperton. There's one issue that I had with one of his rulings, even though that's a contradiction. I feel like he probably has some sort of balance or some sort of test. So he just needs to unravel that contradiction. 2015 Marion decision, you had Danielle Marion and Barbara Parrish who were walking down the road, and they were looking for some money and a ride into town. They come up to one guy, he said no, and then they went up to another guy who was in a barn, and I don't know if he was just rude or what had happened, but they decided to attack him with a rock and a hammer. And it sounded like Barbara Parrish was the one that was doing the whole thing, but Barbara Parrish got 2 years off of her sentence to testify against Danielle Marion. So there is 4 objections. 2 of them were ruled, reversed, and the other 2 were affirmed. And the one that I thought that Caperton really erred on, the contradiction, that's more for him, but the Marion decision, there was a juror, number 78, who was biased. So juror 78 believed that the criminally accused was guilty until proven innocent, which is the exact opposite of how the American court system works. You're innocent until proven guilty. But for this one juror, juror number 78, mentioned the Kentucky Rules of Criminal Procedure, RCR 9.36, 1 says, where there is reasonable ground to believe that a prospective juror cannot render a fair and impartial verdict on the evidence, that juror shall be excused as not qualified. So if you're sitting there saying that the defense needs to prove that that person's innocent, how do you prove that somebody's innocent, right? It's all in court, so whatever evidence you bring into court is all that's going to be, utilized. So they're going to say, okay, you killed the person, now convince me that's not true. Somebody accused you of a crime, so clearly that just must be right. You got to prove that you didn't commit the damn crime. So maybe having an alibi, maybe having, videotape, but then they could say you doctored the video. So God, the fact that that juror had the American jurisprudence philosophy of, U.S. courts, you're innocent until proven guilty, he had it backwards. So he says you're guilty until proven innocent. Well, the defense wasn't able to prove their innocence, and that's why he convicted them. So the question, you can have a loophole. The loophole is a minor loophole, but essentially it says that if a juror says something stupid, right, like, well, no, that person's guilty. They're guilty. Just look at their face. They're totally guilty. Well, clearly that juror is biased and should be dismissed, and you should kick them out, and you should say, you need to clean up your attitude. But if they're sitting there just saying that, they're guilty, they need to prove themselves innocent, well, the loophole is the judge can ask that juror, hey, juror, can you, give a fair and, a fair treatment to this thing? Something about, can you render a fair and impartial verdict on the evidence? And that's it. So if you can render a fair and impartial verdict based solely on the evidence, so the person is sitting there shouting, that person's guilty, okay, you're clearly biased, but can you actually do this case fairly? Yes, Your Honor, I can. Okay, get on in there. That's such bullshit. So that seemed to me, not problematic. That's a reversible error. That one juror could have been the one that convinced everybody else to go along with him, because one more reversible error that Michael Caperton believed in, he says that you cannot be cut off during a cross-examination. You have, exhaust your questions. Just keep it asking questions until you're finished. You can't cut somebody off during a cross-examination, probably not during their closing speech, too. So you get to go on and on during the cross-examination. You get to go on and on with the closing speech. If not, that's a reversible error. So those are the 11, I guess, reversible errors. I need to edit this little paragraph here that I wrote. I want to mention a couple other things, because I had a nice heart-to-heart conversation with Michael Caperton. He reached out to me through Messenger, and we got to talk about a lot of different things, and I asked him a lot of tough questions, but, he answered every single one of them. So before I said vote for Jacqueline Caldwell, but now I'm saying, vote for who you like, Kentucky. It's up to you. They're both qualified, and he's got an extensive voting record, so you can see precisely where the reversible errors are and where they're not. And she hasn't begun to articulate those, yet. I haven't seen anything written, and I've asked her a couple questions, and she's little history. Michael Caperton, he's been the judge for, 20 to 30 years. He was a district court judge. He's now the circuit court judge. He was an appeals court judge. So for 20 to 30 years, he's been a judge. And he's been an appeals judge specifically. So he's actually done the job that he's ran for, the Kentucky appeals judge. He was there for 7 years. He's also got 75 appeals court opinions that were published. That helps to clarify the law. Also shows he's got a body of work that, people, the media, citizens can research and learn about his appeals court policy. Caperton guesstimates that perhaps 20% of the cases that he reviewed were reversed. So most are affirmed, but he does reverse and remand some cases. So because he's been a judge for 20 years, he's got experience, right? He also mentions that the common law, there's common law causes of action in Kentucky law. Colorado does not recognize common law, but Kentucky law does. Michael Caperton believes in the rule of law. He says it doesn't matter if you're poor, or if you're a cop, or if you're a governor or a legislator, you have to treat everybody the same. Everybody's the same. Caperton says that the law applies to everybody, and he didn't say there's specific groups of people. I did, but he agreed with it. So Michael Caperton said that he would take a brief that was written by a regular common citizen just as seriously as one that was written by a lawyer. Now, Jacqueline Caldwell had mentioned that the poor don't get the same access in courts that everybody else does, and I like that she mentioned that, but the fact that he's saying that he would accept a brief that was written by a regular common citizen just as seriously as one that was written by a lawyer, that essentially says the same thing. Now, I don't know if he's been doing that or if he just said that. To me, he did have some useful objections. He said that the citizen who writes a brief is expected to uphold the same standard of law just as good as any lawyer does. So the lawyers have to make sure that they reference the case and they file this paper and they give copies to everybody. The two things that he mentioned was that there must be adequate citations to the record and they must use a 12-point font. Don't use a 7-point font or your brief is going to get, booted out. There's rules. You should print up the Michael Caperton's own words. He says that the briefs must have adequate citations to the record. So not just the laws that were involved, but specifically what happened in trial court. What was the decision? What was the evidence presented? So that way when they read it, then they could go and refer back to whatever crap they have. I don't know if they have boxes or how they get their evidence or how. Anyways, it must have adequate citations to the record. So you got to say the trial court was this, and they decided this, and then here's this. So that's the best that I can explain his position on that. So you need a 12-point font. An appeals brief is limited to 25 pages only, so you can't go over 25 pages, and you must have adequate citations to the record. Now, Michael Caperton actually helped me figure out the entire judge pensions process. The Bluegrass Institute, the Kentucky Center for Economic Policy, nor Chris Tobey, none of these could provide me with an answer about the pensions of the judges, but Michael Caperton did. So I was essentially right. I did exaggerate a little bit about how long they can. With Social Security, you have to have a job for at least 5 years, and then you're going to get your retirement at 67. If you've had a job for 5 years, you're qualified for Social Security already. So I have worked my 5 years easily. Now, a judge, they have to work 8 years to be approved for the retirement benefits that come from the state of Kentucky. Social Security is from the U.S. government. So the judge, they don't get Social Security, so they got to get their retirement benefits from the state of Kentucky. After you've worked 8 years as a judge, when you turn 65, that's when you get the pension. Now, the other part to this that, I thought that you could, just retire right after you're finished, with your judgeship. You can get, reduction in years. So if you work 20 years, for every 5 years, it reduces with 1 year. So if you work 20 years, then you can retire at 61 instead of 65. There's some other things, too. You can take early retirement, and you can take a percentage, 5%, 2.2%, 5%. So you can take an early retirement, and then you can start drawing on that pension before you actually, are of age and you. The issue that I still have a problem with is that the judges' pensions get 100% payout. So if you're a road worker or if you're a teacher and you go up there and you get your pension, you only get half that amount as a teacher. And as a road worker, you only get 10%. So if you're getting paid $50,000 as a road worker, when you go to draw your retirement benefits from the state of Kentucky, you're only going to get 10% of that. And 10% of $50,000 is $5,000. I mean, you're going to get $5,000 for the entire year, and you're a road worker, so you had to been, you were living on a meager income compared to a judge who's getting paid six figures, $130,000 or so every year. So a judge gets $130,000. So if they're in there for 8 years at least, they've already made, $1 million plus. They've had money, they've had power, and they're not going to get their retirement until they turn 65, but their payout is 100%. So while the road worker is getting $5,000, the judges are getting $130,000 every single year until they die. And then that early retirement, some people that I bet the system actually banks on that. Some people might not make it to their 65. Seems like it would be in the judge's best interest to take that early retirement just in case they don't make it to, 76 is the average lifespan of Americans. But, you know, shit happens. Accidents happen, and lots of things happen to where people don't get to live their full 76 years. And so if you don't live, you know, anyway, so I feel like the judges can, you know, it's smart for the judges to start drawing from that retirement right away, to declare early retirement, and then, you know, to start taking their percentages. And but it seems to me that you're paying for their entire lives still. So, you know, I was saying that they were getting $130,000 for the 40 years. Now, that's not the case. They'll get $130,000 every year after they're 65. So for, you know, 10, 20, 30 years, depending on how long they live, they will get $130,000. But they could take that early retirement, so they could, you know, take a piece of, you know, their retirement, which I don't believe is available to any, you know, I'm going to get Social Security when I'm 67, but I can't take early retirement. I can't take like a piece of it right now. I mean, they're using it to fund all these wars and all the tax breaks for the millionaires. I appreciate Mr. Caperton for explaining that, because once you've got your 8 years, you've already locked into that retirement. So anything over 8 years, you know, you might get a year off here and there, but it seems like once you've done 8 years, then you'll get your retirement no matter how much more time you work after that. Two other things I want to mention. I told Michael Caperton, he was saying that all your constitutionally protected rights, because I was asked about a jury trial and your right to a lawyer, and he says that all of your constitutionally protected rights need to be upheld. So your freedom of speech, am I allowed to just, you know, say, fuck you, judge, you fucking fuck? Can I just, you know, use my freedom of speech? So I feel like it's easy just to say all constitutional laws, but I want to know specifically, right? So the right that I mentioned that's enshrined in Kentucky's Constitution, Section 4, is the right to revolution. And he didn't realize there was a right to revolution, and it's never really been adjudicated because it never really came up, but it seems like it could be a convenient excuse for most things. Hey, why'd you, you know, jaywalk? Well, I'm on the way to the revolution. Hey, why'd you take that Snickers bar? Well, I'm on the way to the, you know, the revolution. I need my energy, so I need it. It's for this damn corporate. Just say what Section 4 of Kentucky's Constitution is verbatim. All power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, happiness, and the protection of property. For the advancement of these ends, peace, safety, happiness, protection of property, for the advancement of these ends, they have at all times an inalienable and indefeasible right to alter, reform, or abolish their government in such a manner as they may deem proper. So the right to revolution is inherent. It's a human right, so it's already a natural right anyways, but this comes from the, you know, revolutionary era, and they want to make sure that the right to revolution is always, you know, there. So it's not only a human right, it's not only an inherent natural right, but it's a legal right. In Kentucky, you have a legal right for revolution. Not only is revolution legal in Kentucky, but the last thing I want to mention about Mr. Caperton is he seems to think that the entire court system, this is, you know, the whole reason he had heard that I called him an elite, and he was like, hey, I'm Mr. Humble, and he is very humble. You could talk to him right now, and talk to him right now as a candidate, because if you're the accused, then you're going to be, you know, looking for legal help. But if, you know, you're just okay, okie dokie, you know, honky-dory citizen, well, give him a call, and he will, you know, talk to you. So he's humble. He is humble. Now, my experience with Kentucky courts and his experience with Kentucky courts are polar opposites. So he says that everything's working fine. It's a nice, you know, fine-oiled machine. He says that everything's working well. Jacqueline says justice delayed is justice denied because she's saying the appeals court goes too slow. He said that there wasn't a backlog. He, you know, put all of his opinions out on time. And then on family court, he said, God bless those judges who want to sit and listen to somebody's divorce, which, you know, that's a good point. Who wants to sit there and listen to, you know, these two assholes, you know, bicker amongst one another? And then he says nobody's ever happy. Everybody walks all pissed, you know, as soon as they leave. Mr. Caperton is a circuit court judge, so of course the circuit court judge and the district court judge, he's ran those two things. And the family court and the appeals court, all those courts are working fine. Now, there was one interesting thing that I had said. I mentioned that if a dog bites you and you go to the police and they don't believe you and they don't make an arrest, and then he said, well, you could go to the county attorney and then that's the last if they don't believe you. Well, what the fuck are you supposed to do? The dog is biting you. It's clearly immoral. It's clearly illegal. Here's the laws. The cop and the county attorney don't want to do shit about it. And then when you say, you rip the dog's head off of, off your arm, and you may injure the dog, are you going to get charged? No, it's very important. He said something about that they don't take priorities and they don't chase every crime. So it seems like there's a major disconnect for what's going on in the ground and what's going on in the court. Anything that the police drag in the court is going to get tried. But if a citizen tries to say that this crime happens, I think any and all crimes that are reported should at least be put into the system. It should be reported. Now maybe I thought that was actually a little bit concerning because he was saying that the county attorney will take cases based on if they can convict it. So it's not about the priority. It's not about whether it's, the big crimes, rape, murder, pedophilia, stealing, arson, kidnapping, violence. If it's any of those things, right, then it doesn't matter what how extreme it is. It's whether or not you can prosecute it. Well, that seems to be the wrong sort of litmus test. The major crimes, hey, I just saw, a kidnapping. Hey, I just saw a rape happen. Hey, I just saw a murder happen. You need to go check that goddamn crime right now, even if it's just that one witness testimony. And it is illegal. And so if you can't get the police or the county attorney to do something about it, I think you should have, some other place to go because that's a broken system. That's a broken system. That means that citizens saw a crime and nobody gives a damn. If a cop saw a crime, well, they could just go ahead, make the arrest and do something about it, and now the whole court system listens to them. But if you're a citizen and you witness a crime, nobody's going to pay attention. So he's also talking about cops and the county attorneys. Overall impression, I'm pretty sure is 100% correct. Essentially, I feel like he couldn't find any errors with the appeals court. They're doing perfect, so they can't even be improved. They're doing so great. There's not even anything you can improve on. They're just doing so damn great. So, I think he has an over-reliance on how well the Kentucky court system works. And the last thing that I want to mention is that he just could not believe that a judge would not deprive, that a judge would deprive somebody of a lawyer or a jury. Now, there's two times that, one, she almost tried to deprive me, and then there was another time that was clear as day. So this is Kentucky Court, Shannonbury, Breckinridge County. I said I need a lawyer. She sits me down with some person, the stooge of a court, and then they're asking me questions, and I'm trying to answer, and then she's trying to scribble something down, and then she turns that form into it, and then Shannonbury goes in the back and then comes back out and says, well, your numbers weren't right. She was whispering. I was whispering back, so I didn't check the math on whatever the hell you're talking about, but she tried to deny me a lawyer. She tried to, but eventually, I got a lawyer, a pretty good one too, Josh somebody. And then the other time, I made headline news, not just in Kentucky, but around the nation for getting arrested for a library book. So I had checked out a library book 15 years ago, and then I moved. And so along with the collection of my stuff, I don't even know where the book is today. But apparently I had, gone to the library, checked some stuff out. I had no place to go. I lived one place, I lived another, and then I was looking at homelessness, and so I said I was going to go stay with a friend in Ohio, and then I didn't come back for, a year or two, and I come back to Cincinnati, so it wasn't like I came directly back to Kentucky. So, I took out, 3 library books worth about $50, and I didn't know about it, and the police officer pulled me over for, a tail light or some minor traffic thing, and then ran a warrant, and then this came up and said, you need to go to jail because you had overdue library book. So that whole thing was insane, but that Ken County judge was an asshole. I wish I could remember his name, but he was such a prick. I'm driving 5 hours away. I hit a deer on the way there. He, closes court up early that day, so technically Anyways, go up to the lawyer. He says, okay, what's your deal? And I said, this is my deal, and I want a lawyer, and I want a jury trial. And he says, well, did you drive here today? And I said, yes. And he said, well, that means you can afford a lawyer. If you own a car, you could sell that car and you can afford a lawyer. I deny your request for a lawyer. And then he said, and since you were late, we redocketed you today, but you were late, so we could have went ahead and filed a contempt of court charge on you. So essentially, we worked it out to a more amicable solution. I went back to the library and paid it, and then showed the prosecutor it was paid off, and then everything was good. And the library was so cool about it. I mean, why did you have to arrest me? Why did you have to have a warrant and an arrest? God, if I had been known, somehow just, the police officer could have had discretion for it, be like, hey, you need to take care of this library charge thing here. But anyways, the judge in Kenton County deprived me of a lawyer because I owned a car. So it does happen in Kentucky. It happened to me, and now